In March 2020, Manuel Ellis died while handcuffed in police custody. 3 officers involved in the incident are now on trial. Officers Matthew Collins and Christopher Burbank face second-degree murder and manslaughter charges. Officer Timothy Rankin is charged with manslaughter. Thank you for joining us. I'm Christine Pei. For the duration of the trial, King 5 will recap the biggest developments in the courtroom, and we will discuss what it all means. Today, we sit down with attorney Mark Lindquist, who served as a Pierce County prosecuting attorney for nearly a decade. Also joining us is retired Pierce County Superior Court Judge Brian Tollefson and former criminal defense lawyer and Seattle University professor Mo Hammoudi. Thank you all so much for being here. Well, first, we do want to check in with King 5 Tacoma Bureau Chief Lionel Donovan about what happened in court this week.
The defense kicked off its case this week. The focus, establishing a cause of death for Ellis involving drug use and underlying health conditions. The defense stated that Ellis's methamphetamine abuse and heart health played a role in his death.
The truth, the whole truth, and nothing but the truth.
Dr. Jennifer Stankus testified that medical records from 2017 show Ellis complaining of chest pains, which could indicate underlying cardiac issues. She says these details are vital to understand why Ellis wasn't getting enough oxygen that night.
That can happen either because your lungs aren't working, you're not breathing, or your heart's not pumping. Okay. Or it's not pumping effectively, or it's in an arrhythmia where it's variable.
Ellis's interactions with law enforcement were also a point of focus. Pierce County deputies were called to tell the jury what they experienced trying to arrest Ellis in 2015 and 2019. Deputies from those incidents testified Ellis became aggressive, and it took multiple officers to subdue him. Tacoma police officer Masai Ford, who helped hold Ellis down during his 2020 arrest, also testified that it was difficult to control Ellis. However, Ford admitted that he did hear Ellis say he couldn't breathe.
He said it in a remarkably calm voice, and it was very clear.
And why was that significant to you? And if it was, that you said it in a calm, clear voice?
Because he was making these noises like he was physically exerting himself, and then he just very calmly said, "I can't breathe."
Chad Hayes, who witnessed Ellis getting arrested in 2020, also claimed that Pierce County detectives altered his statement.
Like I said, I read this earlier and I didn't agree with some of the stuff the officer put in here.
Court will resume next week, but only for 2 days because of the Thanksgiving holiday. From the Pierce County Courthouse, Lionel Donovan, King 5 News.
And first thing on Monday, earlier this week, we heard an opening statement from the attorneys representing Officer Matthew Collins. We also heard from the defense's first few witnesses. As Lionel just mentioned, they focused heavily on Ellis's past brushes with law enforcement, specifically on one occasion in 2015 and another occasion in 2019 when Ellis was arrested by law enforcement while high on meth. Deputies who took part in both arrests appeared on the witness stand. The defense also went into challenges that Ellis experienced with his mental health. So let's dive into all of this. We're only getting started. Mo, I want to turn this first question over to you. Do you think that these were the right first witnesses for the defense to present on their first week of presenting their case? And how do you think you expect the jury to react to all of this information so far?
Well, I believe that in a principle of what's called primacy and recency, I would have put on an officer, one of the officers first, that they've promised would have testified, and I would have closed out with one of the officers. But they decided to go into his past. And to be honest, I don't know how much Mr. Ellis's past is going to be relevant in this case. Who he was in 2015 and 2019 only becomes relevant in this case if the officers were aware of that past. And I've heard no evidence that the officers were aware of that past. So what it's doing to the jury is that it's becoming a presentation about Mr. Ellis's character. And Mr. Ellis's character is not in trial right now. It's the officers' behavior on the night of the incident and what they knew and what they intended to do or what they did not intend to do. Sure. So that's my position on that. But the presentation, the opening statement by defense counsel was well put together. Right. What he did was effectively create a narrative between a protagonist and an antagonist, making Mr. Ellis the antagonist and making the officers the protagonist.
Sure, and Mark, let's turn this over to you. The state fought heavily, actually, to have some of these witnesses and some of the information excluded. Can you explain some of the thinking behind that? How do you think the cross-examination, for example, has been, how that went pretty much this past week?
Right. Well, Mark Twain always said the best predictor of future behavior is past behavior.
Yes.
And others have said that as well. And clearly that's what the defense is banking on here by trying to bring in Mr. Ellis's past. And you'll often see that in a case where the defense is going to go after the victim or people around the victim. But especially in a case like this, where the question really is, why did these officers use the force that they did? And so I agree with Mo, the defense attorney, Casey Arbins, did a good job of laying out the defense in his opening.
Yeah.
As we talked about before, one of the advantages of multiple defense attorneys is the prosecution gets one opening, but they got two.
And right, and they saved the opening statement for Matthew Collins, for him as a defendant, in the middle. They just started off with the two first ones, and then they kind of was able to insert that in the middle of it. But Mo, to your point, you would have liked to have heard from, let's say, Officer Rankin, who we know is scheduled or planned to testify and take the stand. You would have liked to hear from him first, right off the bat.
Absolutely.
Yeah.
I think what you want to do is that if the defense lawyer's narrative is that these officers behaved reasonably and had no criminal intent, put one officer out right out of the gates to establish that.
Sure.
And then you can have another officer close. But what kind of is going to be a challenge for them moving on is that if they put the officers so close next to each other testifying, and if there are inconsistencies between the testimony and they're testifying in sequence, that's going to create a little problem in the way in which credibility is assessed.
I gotcha. Well, I'm going to turn this question over to you, Judge. So much of the discussion is over admissibility of evidence and some of the witness testimony. What would be the guide really in allowing this? Because I want to say so much of the day is someone objecting, and they all get up, the jury has to leave the room, then they discuss for quite a long time, then they come back. It's kind of this back and forth. Is this pretty typical?
It is pretty typical, yeah. Especially when you're talking about character evidence, and all of the evidence concerning Mr. Ellis is character evidence, and there are certain exceptions. The general rule is character evidence is out.
Sure.
But there are certain defined exceptions in our evidence rules about when you can get character evidence in. One of the exceptions is to establish a pertinent trait of the victim. So there had to have been a lot of arguments about, and obviously persuasive arguments to the judge. And the judge has to make a decision about whether this kind of character evidence fits within the exception that's allowed for bringing in victim behavior. The other thing to know is that the judge has what we call discretion to rule on these things, and the standard of review is abuse of discretion. Did the judge abuse his discretion by allowing all of this testimony in? And that's a pretty tough one to turn around on appeal, if there is an appeal and there's some ruling about that.
Sure.
The standard generally is, would any reasonable judge make the ruling that Judge Shushkoff made? I mean, that's pretty...
Well, have you observed anything, especially this past week, that stood out to you?
What stood out to me was the 2015 incident. That's pretty far back, 5 years, and I was very surprised. But obviously the attorneys made some very strong arguments and that persuaded the judge that he needed to allow this kind of evidence in.
Sure. Moving on a little bit, we did see a bit of a shuffle with the jury this week. One juror actually has been excused because they came down with COVID and an alternate has taken their place. There was also some waffling about whether they would pause the trial until Monday or if they would continue while the other jurors elected to keep on going. This sort of hints at how difficult it is to run a trial of such significance like this. Judge Tolson, if I could just direct this over to you again. What are some of the other things that there's so many extraneous things that happen when the jurors are not there. There was even some discussion, I think the judge had sort of touched on some of the demonstrations that were happening outside of the courtroom as well. The judge needs to sort of juggle all of this at the same time.
That's right, and it's a tough job, and he doesn't have a big staff to do all the stuff that he has to do, so there's a lot of pressure on the judge to try and make decisions and make them quickly, too.
Did Mo and Mark, did you have any thoughts on how the judge has approached the prosecution and the defense side and just his tone even? I mean, how do you think this is pretty typical for them to basically kind of listen to see what he says? It's just sort of the run of the mill. This is how things are going to go.
I've actually tried cases in front of Judge Shishkoff, and he's a good judge, and he's one of those judges that tends to let both sides argue their theory of the case. He tends to let evidence in, and he's doing that here.
All right. Thoughts?
I mean, I think my thoughts is that the amount of evidence that is coming in with respect to Manuel Ellis's past, I don't know if I could ever have gotten that much amount of evidence in one of my cases that was not involving a police officer. The majority of my career, I represented people who were indigent, could not afford a lawyer at the public defender's office. Sure. And just the vast amount of evidence that came in with respect to Manuel Ellis and his past, I could never get that much evidence in with respect to a victim. So I've seen that. That's a clear distinction I've seen in this case in my experience.
And I would agree with both the judge and Mo that a lot more evidence is coming in about the victim's past than you might normally expect. As Judge Tolson said, they must have made some persuasive arguments in the motions in limine.
Sure.
It's consistent, of course, with the defense theory, which is that Mr. Ellis was aggressive and he was violent and he was high in methamphetamine. And so they tried to give other examples of that. In 2019, it seemed me I could see that one coming in. I was also a little surprised the 2015 incident came in as well.
Yeah, several years ago. Turning to another aspect of something that we want to highlight this week, perhaps one of the biggest moments from this week. For the first time in the trial thus far, we have heard testimony from an officer who responded to the scene on the night Ellis died. Officer Masai Ford took the witness stand on Wednesday. Again, he was Officer Rankin's partner on the night they responded to backup officers Collins and Burbank. Ford is not charged in this case. Keep that in mind. Ford said when he arrived on scene, it did not look like officers Collins and Burbank had control of the situation. He said even with backup, Ellis was difficult to restrain. And here's a piece of Ford's testimony.
And how tightly were you holding on to him?
As tight as I possibly could.
Okay, did you ever say you did that holding on for your life?
Yes, ma'am, I did.
Why did you say that?
I was holding on. It was like, now I weigh about 210. Back then I was about 170, maybe even less. And it took all my strength to hold one leg.
So Officer Ford, he just testified, he was there. He put some pressure on the leg. That was the extent of his, I guess, involvement in that situation. But Mo, you touched on this before. You were arguing that we should have heard maybe from Officer Rankin right off the bat. We heard from Officer Ford later on in the week. How do you think the defense approached this strategy?
You know, upon reflection, I would have led with Officer Ford. That would have been my first witness. And the reason why is that Officer Ford is essentially testifying as a conduit for the charged officers and saying what they did on that night was totally reasonable and fine. Yeah. And they've now put on the testimony of the officers without even having put on the officers to testify, which I thought was very important. The second thing that made his testimony so compelling was that he has not been charged. Right. And so you have one officer involved in a group of officers who is not charged sitting there testifying. And he so happens to be a person of color. And so whatever race issues are circulating around the margins of this case, that this incident with Mr. Ellis had nothing to do with his race. That's the implicit message that the defense is trying to make. Now, they may have gotten themselves in a little bit of a pretzel with his testimony. In that, Officer Ford testified at great length about the character of the police officer. And when you do that, you've now opened the door to bring in evidence, any evidence, that would impeach that character from the officer's past. Could be aggression, his police records, his personnel records. And the defense attorney made such a broad presentation about Officer Collins' history, going back to college. He's a duck. He was a military, served honorably. You can go back and bring in evidence going that far back that shows that he was aggressive in the past to support the prosecution's case.
Sure.
That they did not act reasonably, and they could put that evidence on in the prosecution's rebuttal case.
I think some of the line was questioning, I mean, obviously Ford was Rankin's former partner, and I think he did allude to the fact that they hung out outside of their work. They had, I think, potlucks, and they had dog hangs and stuff, so that is an interesting point. Mark, let me take it over to you, because I know you said from the very beginning that you think all of the officers who are charged are going to be testifying, and Mo brought up a very good point that instead Officer Ford is a conduit for the other officers. Do you think that this would be a good way to maybe get a sense of how Officers Collins and Burbank, how their actions were without actually having them testify, or do you still think they're going to take the stand?
Absolutely, they're still going to take the stand. And Casey, the defense attorney, pretty much said so. And I thought he did a good job in his opening. He got up and said, hey, you know, my client, just like you jurors, he's been sitting there watching, and he is eager to get up there and tell you what happened. And furthermore, I thought Casey had a nice self-deprecating touch when he said, you know, my client's sitting there frustrated because he's got to listen to his dumb lawyers talk for him. Yeah. And you could almost hear the jurors chuckle in the background. So I thought Casey did a good job, a little self-deprecating humor, which goes a long way to lighten the mood, but setting the stage for the fact his client's going to testify.
There was that, you just reminded me of a moment when Officer Ford was testifying. He was describing how Officer Collins looked in comparison to Officer Burbank, and how Officer Collins was a lot larger, and there was this chuckle among the jury. When you have those light moments like that, is that a plus for the defense?
Absolutely. And what counsel for one of the officers did, she got up and had the officer put the cuffs on her, had Ford put the cuffs on her, and they had also a little moment. All of these moments are techniques that the defense lawyer is using to build connection, build rapport with the jury, because ultimately you're going to be standing in front of them and asking them to acquit your client, and you want them to have some sense of connection with you.
Yes.
And they're doing a very good job at that.
Well, Judge, let me ask you this, because that moment when defense attorney Ann Bremner allowed the handcuffs to be put on her just as a demonstration before the jury, were you surprised that that was allowed, or is that pretty typical from the judges?
I wasn't surprised. I mean, Ann Bremner has done a lot of trials.
Yeah.
She's got a lot of good tactics and strategies, and I wasn't surprised that this would happen.
Sure. Just going back to Officer Ford in general, his overall demeanor, your thoughts, Mark, I'll start with you.
Very professional, very likable. Apparently doesn't have a lot of experience testifying, but I didn't think it showed. I thought he did a good job.
Mo, what are your thoughts?
Compelling.
Yeah.
He acknowledged that he was nervous. He listened to the questions. He looked at the jury. He answered the questions directly as best as he could. I thought so far he was one of the most powerful witnesses in the case.
Okay, moving on to some of the other testimony this week. We also heard two expert witnesses for the defense contradict the opinions of experts who testified for the state. And first up was an emergency physician who attributed Ellis's cause of death to meth use. And here is that moment.
So my opinion is that Mr. Ellis had a toxic and lethal amount of methamphetamine in his system, and that the effects of that with his underlying heart disease caused his death.
You'll remember previously an expert cardiologist testifying for the state, for the prosecution, said that Ellis's heart attack was caused by oxygen deprivation, and furthermore that it could not have been caused by meth use or an underlying heart condition. We also heard from a training sergeant, but we'll get to that in just a bit. But before going into more of this expert testimony, Mark, I'll turn it over to you. We heard from several medical experts during the prosecution's part of the case. But how do you think the jury is going to be comparing all of these testimonies now that we're hearing the first medical expert from the defense?
As we talked about in the beginning, you're going to have these highly educated, highly informed, highly professional experts totally contradict each other. And as the judge said, the jury's going to get an instruction that says you are the sole deciders are credibility.
Yes.
You give whatever weight to the experts you want. In other words, they're going to get an instruction that tells them they can actually ignore the experts if they want. And what you're seeing here is experts canceling each other out.
Can it be confusing for the jury to hear from so many different sides and perspectives?
No, I don't think it's confusing to the jury at all. What I think you're going to see is, I don't want to predict the future, but I think the juror is going to pay a lot more attention to the eyewitness testimony and to the video testimony and the photo testimony than they are the experts. That's what I think.
Well, speaking of experts, the state's use of force experts said that the level of force that the officers used against Manuel Ellis was excessive, but on the witness stand yesterday, a training sergeant for the Renton Police Department disagreed, and here is what he testified.
But broadly speaking, the force used to do what they're trying to accomplish was appropriate.
So this all unfolded as expected. You know, this is the defense's side showing their use of force experts. Mo, is it a coincidence that both sides were able to find expert witnesses who would say what they wanted them to say? It's pretty much a given.
No, it's not a coincidence. Sure. Everybody has somebody who they can speak to and say, here are my facts, and do you have an opinion to give that is helpful to me? And, you know, the expert will come in and testify. I mean, a good example of it is the medical examiner testimony and the doctor's testimony. I mean, to narrow it down, to make it very simple, the state's expert is saying he couldn't breathe, therefore the heart stopped. The defense witness is saying, no. Really bad health, heart stopped, couldn't breathe.
Yeah.
That's really as simple as it comes. But I think for the jury's perspective on that testimony, I would say that you find your victim as you find them. I can't, in any criminal case, if somebody is dead, say, oh, the person was a diabetic, the person had all these health problems, therefore, you know, it's not my responsibility. I think that muddies the water for the jury. On the excessive force expert, I think that the jury's ultimately going to decide, as the judge said, they're going to look at the video and they're going to remember the testimony of the witnesses and ask, did the officers initiate force or not?
You know, during the prosecution side, Mark, we heard from a lot of medical experts, but Mo, you touched on this before. This is, you had mentioned that this is very much a use of force case. Has there been too much discussion in the cause of death and the medical side? And is there going to be enough discussion on the use of force aspect of this trial?
So use of force, I think it's important for the public to understand that civil use of force and criminal use of force are distinct areas of the law. In the civil context, it's the objective standard. What would a reasonable police officer do under the circumstances? In the criminal aspect, it's the subjective intent of these officers. Right. So really the focus is, did the officers act criminally? And that starts right at the beginning. If Mr. Ellis was doing nothing, or behaving consistent with the law, and the officers just attacked him, then he wouldn't be dead, but for that attack. I mean, It's really that simple. He would still be alive if he didn't have an interaction with the officers. So really, we got to focus on their subjective behavior. That's why I don't think the use of force necessarily helps that much. I think it provides some context, but you had already the police officer who was there at the scene testify about the use of force and tell them how much pressure they were putting on him. I think that would have been sufficient. I wouldn't have called the experts.
Mark, what are your thoughts?
Well, I've already voiced you. I agree they probably called too many experts in the prosecution case. Another thing is worth emphasizing is just how much higher the standard is in a criminal prosecution than a civil prosecution. Number one, the standard of proof beyond a reasonable doubt for criminal, just more likely than not for civil. Number two, in a criminal case, murder, you have to show bad intent, some intent to assault. And then thirdly, and this is harder to quantify, but it's in the back of the minds of the jurors, it's easier for jurors to give money to a victim's family than it is to send someone to prison.
Yeah, right.
So this is a tough case the prosecution's taking on.
Very, very difficult. So we have the first week down for the defense. Any final thoughts on how things are going so far? We're getting a taste of where the defense is going with things. I'll start with you, Judge. Maybe your thoughts on just how things have been carried out.
I'm going to step out of my judge role here and just the feeling I have about why we didn't hear from Rankin or Collins or Burbank before the Thanksgiving break is they didn't want that testimony to get lost.
Sure.
I think they wanted to put all that strong testimony on after the Thanksgiving break. So that's my final thought about that.
That's such a good point. We're thinking about turkey. We're thinking about the holiday. You know, you want to have the strong witnesses maybe a little bit afterward. Mo.
Yeah, I think what I would say is that where the strength of this defense lies is officers testifying to the fact that they did not get up that morning with the intention to cause somebody's death.
Sure.
And that they get up there and we see a semblance of remorse, not because they believe that they have committed a crime, but because of the outcome, of the unfortunate outcome. I don't think that's got to be clear to the jury. Because in my experience, when the jury feels that there is a semblance of remorse from the individual that is accused on the stand, they take and place a great deal of emphasis on that in deliberations.
Certainly. Mark, final thoughts?
Well, as you know, Christine, I'm just sitting back waiting to see what the officers say on the stand.
Yes. We're going to have to wait and see, yes, after the holiday, that is for sure. But thank you so much, as always, for breaking everything down. Very, very insightful, and there's a lot more that we're going to be piecing together. Thank you again for being here. By the way, we will have much more trial coverage coming up during our newscast. And next week, again, there will be no recap due to the holiday, but you can tune in to our streaming app, King 5 Plus, available on Roku, Amazon Fire, and Apple TV. Our weekly recap is also available on our YouTube channel. As always, you can keep up to date with our trial coverage on king5.com and on our mobile app.